Hello, everyone. Give everybody just a second here to get into the room and get their audio working. Get started. Okay, looks like everyone's flowing in. Thank you for joining us today. This is the current overview of the Hair Relaxer Litigation, sponsored by Verus. CLE credit for this program is offered in California, Illinois, New Jersey, New York, Pennsylvania, and Texas. You'll receive the link to submit for CLE credit at the end of the webinar in the chat and later today in a follow-up email with the presentation materials. There will be 3 CLE code words provided in the chat throughout today's presentation. Please make note of these code words for your CLE credit. You can use the chat to submit any questions you may have throughout the presentation. We'll have time to answer them at the end. I'd like to introduce Mark Evelyn, founder and chief strategy officer at Verus, to start today's presentation. Hi, Mark.
Thanks, Allison. I'm Mark Evelyn. I'm one of the co-founders of Verus, a litigation support firm focusing primarily on the mass tort and class action litigation matters. And I've been involved in the administration of mass tort cases since approximately 1992, when I saw my very first asbestos case file. It's my honor today to serve as your moderator and also to be joined by Lucy Banks Smith, an attorney with Motley Rice, who's currently deeply involved in representing plaintiffs in the hair relaxer and paraquat litigation. Lucy Banks also has represented plaintiffs in Roundup cases and other litigation involving toxic ingredients in consumer products, as well as faulty medical devices such as Allergan lap bands. She works closely with many of the attorneys in the hair relaxer MDL leadership and is with me today to provide us with an overview of that case. In today's discussion, we'll cover a number of topics, including the timeline of the litigation, how we got to where we are, and upcoming events of importance, as well as an overview of the products at issue, the alleged harms, filing trends, and critical case management orders, and discovery of motion practice in the case. We'll be sure to leave plenty of time at the end for responding to questions from attendees. And once again, as Allison said, thank you for joining us today. Let's get started. Lucy Banks, why don't you start off with an explanation of the timeline of this case, how we got to where we are today in this MDL, and where we currently stand. And please forgive me if I jump in as you're talking with questions, like the curious toddler that I can sometimes be.
No worries. That sounds great. I appreciate y'all having me here today. So again, I'm Lucy Banks Smith, an attorney here at Motley Rice. I'm working very closely on not only our hair relaxer litigation cases that we have here at Motley Rice, but with the MDL on a larger scale. We have multiple attorneys, Fidelma Fitzpatrick and Tope Lemieux, who are on leadership of the hair relaxer MDL. So deeply involved in that, and I'm excited to be here to provide an update and answer any questions that y'all might have. So yeah, I'll start with just kind of going back as way of background to back in October 2022 when this all kind of got started, and that was after the National Institute of Health released a study on that date, so in October 2022. And that was a study using data from a larger research study, commonly referred to or recognized as the sister study. And that study was studying approximately 34,000 women from ages 35 to 74 over about a 10 or 11 year period. And ultimately, what that study found was that women who frequently used chemical hair relaxers were more than twice as likely to develop uterine cancer over those who did not use them. And essentially, these findings in this October 2022 study were the first epidemiological evidence associating the use of chemical hair relaxers in uterine cancer. So these studies linked the chemical hair relaxers to multiple types of cancer, including uterine, ovarian, and endometrioid. So this is really the jumping off point, as the first case was not filed long after this study came out. And so the very first case was filed in Illinois on October 24th, 2022 by a 32-year-old woman against L'Oreal and other companies that manufactured and distributed these chemical hair relaxers, claiming that her long-term use of them was the cause of her uterine cancer. And so she further alleged in that lawsuit that the defendants named in the action, which again included L'Oreal and other companies that had manufactured and distributed these products over many years, that they marketed their products as safe and did not warn the customers and consumers about the increased risk of cancer associated with them. And so after that first case was filed, we see many more cases start to get filed. And then that brings us to November 2022, when plaintiffs' counsel for these various plaintiffs across the country filed a motion to consolidate the related lawsuits into an MDL. Um, the MDL being formed, allows more streamlined discovery and the combination of resources across law firms and just help with consistency across pretrial rulings. Because with the number of cases now, I think it's up to about 10,000. Having those consolidated in front of one judge, there's many benefits there. Defendants argued against that in December 2022. So ultimately, there was a hearing held in front of the judicial panel in January 2023 to determine whether these lawsuits would be consolidated. And they ultimately were. So in February 2023, as you've noted here, the MDL for hair relaxer marketing, sales practices, and products liability litigation was officially approved and assigned to U.S. District Court Judge Rowland in the Northern District of Illinois. So that's how.
Lucy Banks, if you don't mind me
Mhm.
interrupting here with a question. For
Mhm.
those who may be listening in who don't spend most of their time in MDL world, what was the real tipping point that led the plaintiff's bar to apply for MDL status in this case, versus proceeding in state courts?
Yeah, so I think there's various factors. And, there are cases, which I think we include this in a later slide, but there are cases simultaneously filed in state court who have not necessarily joined in the MDL. And so a lot of different factors go into that. Really, those keys are, the necessity of having consistency and the resources to consolidate in an MDL. And then a big part of that is the MDL resources. If you file a case there, and it's part of the participation agreement, which we see come up later as one of the criteria for the bellwethers, then you're working with other law firms, sharing resources, that pretrial discovery versus um, perhaps like if it's filed in state court and not a part of the MDL, then you don't get the benefits of that participation agreement. Does that make sense?
It makes perfect sense. So it's sharing the burden.
Yes, yeah, exactly. Exactly. So after the MDL was formed, we get to where plaintiffs file a master complaint, which is essentially looking at all these plaintiffs that have filed cases and consolidating the causes of action, all that into one master complaint. And then the court ultimately approves a short form complaint. And that is going forward, any plaintiffs that are going to file into the MDL will complete the short form complaint, once again, helping to streamline the process, but also really lays out the key points that the court and defendants need to know about these plaintiffs' allegations. So that includes them including the dates of their use of chemical hair relaxer products. And then they're also have to identify the specific brands of the hair relaxer products they used and the manufacturers, whether they were purchasing those or having them done at a salon. And then as well as their medical information, such as cancer diagnosis and diagnosis date. So it gets the court that basic information. So that's kind of how we got to the short form complaint. And then ultimately, those are used in this bellwether process, which you have noted, which was ultimately expanded. So I'll touch on, we only get to the bellwether process, of course, after the judge denies the defendant's, key dismissal motions. So the case continues to move forward. And during this time, more and more cases are being filed into the MDL. So as of February 2025, the judge ruled that, originally there was going to be 16 cases that they were going to choose from in the bellwether selection process. Um, and the court ultimately said, this needs to be a larger pool of cases. And that's because background on the bellwether process in general and the benefits there. The court said, the aim of the bellwether process is to garner information useful to both parties to evaluate both the strengths and weaknesses on both sides of the case. And so, for in order that to happen, the results of the bellwether trials must be reasonably representative of all the cases in the MDL. And so, knowing that background, the court um, said, whereas the parties agreed to originally 16 cases to be eligible, or like in that initial pool, she increased it to 40. So both parties were to submit 20 cases. And in order, how do you get from, say, there's 10,000 cases to that 20? And the court said, the cases that could be potentially eligible are those that were filed on or before February 2024. So you're looking at that earlier pool of cases. And then I mentioned the criteria about being a part of the participation agreement, and then also those qualifying cancer diagnoses.
So Lucy Banks, what is that pool of cases that are actually in that bellwether pool? How big is that pool of the cases filed before February that are also meet the other criteria?
Yeah, so I think we're looking at, it was about 6,500 cases. And then, it goes through a series of vetting. So, that's across different firms again, back to the MDL landscape. And so those went through, then the next level of vetting of the medical criteria and what the court wants to see as far as the cancer diagnosis and medical information. But it was looking at, from the start about 6,500 and then getting down to that number to find, okay, what's reasonably representative to be a part of this initial bellwether pool. So that touches on how that was expanded. And then now is, still in that process as of just recently this summer, the court has been ruling on ongoing discovery disputes that are specific to those individual plaintiffs, because essentially when those bellwethers were chosen into that initial pool, then defendants and plaintiffs both get the opportunity to do, like a deeper dive on these specific plaintiffs and serve additional discovery. So that's kind of where that process is right now. And so as that runs simultaneously, it also is going along with the close of discovery that we're coming up on. So the court at the same time, either at the same time or right around then that she expanded the bellwether trial pool, the dates of discovery had been set. So the written discovery was set to close on February 28th, 2025. And then the oral fact discovery, so the depositions are set to close on September 30th, 2025. So just right around the corner. So we have lots of attorneys across the country conducting depositions. I'm very busy right now doing that, which will then bring us to ultimately Science Day, because the court wanted to, make sure that Science Day would be scheduled after the close of discovery. So that will be January 2026, which is on January 8th, where both plaintiffs and defendants will have the opportunity to present to the court. I think both are going to do about a 2-hour presentation of the science, the medical research and studies. And the court's emphasized again in orders that this is an opportunity to educate the court on the science and the background of the case, not to necessarily, advocate for, their side of their argument, but really to educate the court on more of the nitty-gritty with the science.
And you may get into a little more detail of this later in the discussion, but just for my edification, is Science Day fairly common in MDLs? Is this a fairly new feature of MDLs, or has this always been there?
So I don't know if it's always been in MDLs. I know with other MDLs going on right now that I'm a part of, I know there are science days. So I know right now it's kind of common. I think there was recently one in last year or so, and it was Ozempic, I know, that MDL that's going on. So I don't know initially when those started, but I know it's common now across them.
It sounds like a lot of fun. It kind of sounds like a middle school science fair, but I'm sure it's not fun for those who are involved in it.
Right. Well, actually, when I was checking back at my notes and looking at the court order of, the schedule for Science Day, I was thinking to myself, I don't know how both plaintiffs are going to do a 2-hour presentation and fit everything they want to in 2 hours, and how defendants are going to do the same thing. So stay
Well,
tuned.
Which raises a different question. Is it literally one day on the court's calendar?
Yeah, so it's
So you've got to
truly
cram in all of your scientific evidence and the facts you want to present to the court into a very, very tight time window.
right, exactly. So I think it's truly like 9 a.m. to 11 is the plaintiff's presentation on January 8th, and defendants is 1 to 3. Of course, the court reserves, if any experts that you're bringing in or medical professionals to speak to science and literature, have them stick around in case there's any questions in the coming days, any presentations or displays, bring the court a copy. And then the court also, this is an interesting point, just thinking about, talked a lot about the MDL, which is in front of Judge Rowland, who Science Day will be presented to. Then there's those state court cases, and she, is afforded and I think is going to invite those state court judges, any that would like to attend to hear, the same science and presentations. So, but yes, all of that to say, definitely consolidated to just truly one day. So we'll see how much follow-up comes out of that. I'm sure there'll be lots.
Well, I think we'll move on to the next slide. So why don't you give us a little bit of background on the products that are actually at issue here? Because one of the questions that I have, not having had any active involvement in the hair relaxer cases to date, is when we talk about hair relaxers, are they all of the same type of product, or is there a whole range of products that used for different purposes that may be involved here?
Yes, so I guess this might be a long-winded way of answering your question. So there's definitely a lot of different brands of chemical hair relaxers. Um, So I think in the first wave, there's two wave of defendants now because there's so many companies that have manufactured and distributed these. So like in the first wave, we have at least 9. So like L'Oreal, Revlon, Strength of Nature. And so they each had were developing their own brands of chemical hair relaxers. It's like Dark and Lovely is a very common one of L'Oreal, but now there's Dark and Lovely Super Strength, Dark and Lovely Mild, different like sub brands under that category. So yes, in some ways, a lot of different products. And then also, when we say Dark and Lovely chemical hair relaxer, that chemical hair relaxer itself is part of a kit. So there is several different products within that one kit that are used as a part of the chemical straightening process. Whereas if you think about picking up, shampoo at the store, that's just one bottle of a product.
And are there, obviously, each of those products may have a slightly different formulation. Are there common chemical constituents in each of these products that are suspected of being the carcinogens that could be giving rise to these cancers? Or are there multiple different constituents that could be at issue here?
Yeah, so I think yes to both of those questions. If I say yes, I think that's something that we are only learning more about during the discovery process, and our science committee could probably speak much more to that. So I don't want to step on their toes there, but we're paying very close attention to the proposed formaldehyde ban, which again was just proposed. I think it was October 2023. And that was, that's one particular ingredient. Whereas also, you look at like the long ingredient list, and it's a lot of figuring out how do these mix together? Is that dangerous? And what all is in these products due to the, various number of them.
And have these products changed over time? How long have these products been on the market?
Yeah, so
The history of their use and availability.
right. So we've had clients, there's plaintiffs in the litigation who have used hair relaxer products going back to the, mid early 1900s, like 1970, 1960, whose grandmothers used them and their mothers used them, and, used them over their lifetimes. There's a big sense of brand loyalty, is one way to think about it. So figuring out, and it's interesting in talking to the plaintiffs, and them identifying the products that they used. They recognize them based on, this goes into that next piece of marketing. They're like, I would recognize that anywhere based on the packaging and what it looked like because they know, oh, my grandmother used that one and my mom did, and I also did, and they applied it to my hair, so they recognize it pretty easily. Now, that's something we'll learn, during discovery, and as we continue to assess the discovery we receive following the close about, were there reformulations? What were those reformulations? And we see changes of marketing over time. So that's something that, the product name might even differ a little bit. But with the brand loyalty, someone might still, go to Dark and Lovely products over another one, even if its marketing has changed a little bit or perhaps the name changed.
Are there any significant shifts in that marketing over time that are at the heart of the allegations in these lawsuits?
Yeah, so one thing that we see is just some general points on the background of the marketing. If that really is, it's in the name of the MDL, the marketing and sales practices, um, of how heavily these products were promoted. And historically, black and brown hair textures have been discriminated against. And this really goes to the heart of that. Cosmetic companies have used, and this is an example through their marketing, have used the branding and slogans to reinforce the Eurocentric standards of, the chemical hair relaxer products are used to straighten hair versus the textured, more natural hair. So you really see that in their marketing over time. And so then it really gets into but have they fully disclosed, the potential harmful impacts and effects of these products? And I think, I noted, I think this might be in the master complaint, that the hair relaxer product market alone is worth hundreds of millions of dollars annually. So in late 2024, it was expected to come out around 719 million, around about that number. I remember seeing somewhere. So, to the marketing element, their marketing is was working as far as what it was doing and how heavily it's promoted.
This may be preempting something you want to talk about further on, but I take it these products, many of them are still on the market and being actively marketed and sold around the country.
Yes. Yeah. And of course, can speak to exactly, which of the nine companies or defendants in that first wave, which of their chemical hair relaxer products either are or are not on the market. But I know that, yes, there are chemical hair relaxer products still out there on the market today.
And I assume still many still using the same chemical constituents that are at issue.
Yes. And that's something as far as, yeah, we haven't, we'll have to kind of figure that out more in discovery if those have changed. But I think the assumption is that those, they are the same chemical hair relaxer products that have been promoted over time and been marketed and sold.
So I think you already touched on this in the explaining the timeline of this litigation, but could you expand a bit on the specific forms of cancer that are at issue? Um,
Yes, so they're all qualified as reproductive cancers. So ovarian, uterine, and endometrioid are the cancers, which typically requires, as far as treatment for the plaintiffs, full hysterectomy, or partial hysterectomy, and various types of therapy, chemotherapy, radiation therapy related to their cancers. So those are the qualifying cancers, so to speak, and especially for like that bellwether pool. And so those will be the ones that the court is educated on during Science Day about those cancers and then how they are associated to the use of these chemical hair relaxers.
so it specifically does not include cervical cancers.
Correct. Correct.
And were those three specific types of cancers, were they all identified in the sister study that brought this all to light, or have
Yes.
some of them been identified since that study?
So I believe they're all in that either the October 2021 study that gave way to that October 2022 study. So they're referred to as like the Chang and White study, and are cited in the master complaint. And it's those two that link to the uterine and ovarian endometrioid stemming from that. Of course, who knows down the road if something like cervical cancer could be linked to it, but currently, just based on what the science and literature supports, it's those three cancers, just based on the studies that are out there in literature.
Right. Well, as far as if we could move on to the filing trends
Mhm.
to date. You've mentioned that roughly 6,500 filed through, I think, February of 2024, and that's now expanded to roughly 10,000 cases. In my experience in mass tort, I've done a lot of liability forecasting, trying to predict the future of how many claims may arise, how much it may take to cost to settle those cases. Um, are there any forecasts of future claims arisals here? How much bigger could this grow beyond the 10,000 cases that have already been filed based on current understanding of the latency period and the fact that some of these products are still on the market?
Right, right. So without being able to predict, number exactly, but to your point, these products are still in the market, and we, have cases being filed every day still, which is important to note. Of that number is only growing as people are being diagnosed with cancer. We have clients that are calling that have been diagnosed as recent as a month or two ago, and then later hear about this lawsuit and about the potential link between their cancer and use of hair relaxer products. And so this case, just got started, a couple of years ago, and we still see them consistently, clients reaching out and filing their cases. So predict that it will only continue to, sadly, unfortunately. Um, so yeah, we'll see kind of, how big that gets, but as they, wouldn't be in that initial discovery pool for bellwethers, but these cases are still continuing to be worked up, and plaintiff fact sheets submitted, which is that second process, second step after their short form complaint is filed, which is giving more detailed information about their personal information, background, and use of chemical hair relaxers, and then also their medical information. So defendants are continuing to get that for, our plaintiffs as they're still getting filed.
Imagine that issues around what the latency period is will be one of the key things presented by both sides in Science Day, I would imagine.
Yes, I was going to say, I think that, yeah, that will definitely I play into Science Day. So we'll have to circle back after the 8th of January to, see what both sides present there and how that could only, right, change, predictions and increase that number.
All right. Well, maybe we move on to our next topic, which is maybe expanding a little bit on Science Day. In addition to latency, I know you can't reveal any specifics of what your side of the V will be presenting on Science Day, but what are the key issues that the court is interested in hearing from the experts on? In addition to latency, what other issues does the court want to be informed on?
Yeah, so I think really the court, has broadly said that they want the presentations to be focused on educating the court on the scientific and medical concepts, including any literature and studies that the claims and defenses will be based. So the court, speaks broadly in writing that in the order, but really it's, if these first lawsuits were filed based on that October 2022 study that we started out talking about, really digging in deeper there to those studies, and then any studies or research that has been done since then. I don't know, what defendants, what resources they'll be looking at in their science and literature. But, I think we really talk a lot about this October 2022 study. So digging in deeper there, and imagine the court when you get educated more on not only that study and, the research leading up to that, but then anything else that will be supporting the claims and defenses, which that's something we can either get into now or at a later slide, but just, the claims I've talked about the master long form complaint and the short form about those claims. And so I could go into a little bit, what those claims are from the plaintiff side. And that might give some insight into what, Science Day will be trying to back
I,
up.
I, I think there's no rules here, so we can go into that now
Well, great.
if it makes sense.
Um, so in the master complaint, there's a long list of causes of action that then are, like I mentioned, incorporated into the short form complaint that was approved by the court. And those include causes of action for negligence, gross negligence, negligence per se, and various strict liability claims. So design defect, failure to warn, breach of implied warranty, express warranty, and so that really goes into kind of the regulatory framework and what exists. When we think of, and you're having experience in the mass tort realm, when you think of a medical drug or device case, you're thinking of things that have to be approved by the FDA. And so while, chemical hair relaxers and our personal care products like shampoo aren't being approved by the FDA before they go on the market. There are laws around what can go on the market and what needs to be disclosed. The two biggest ones being the Federal Food and Drug Cosmetic Act and the Fair Packaging and Labeling Act. So really the cause of action here arising out of that Federal Food and Drug Cosmetic Act, which expressly prohibits the marketing of adulterated or misbranded cosmetic products in interstate commerce. So you hear that, marketing element again and how that plays into that of what was or was not included on these products to make consumers aware.
Those are both federal statutes. Are there any, and this may get to the heart of why certain cases are proceeding at the state level. Are there any state laws where there may be tighter regulations over these consumer products, these types of consumer products?
Yes, that's something to your point being investigated and fleshed out more in at the state court level. There's cases filed, like I said, not into the MDL, but in state court, um, even in Illinois. So in Cook County, there's a state court track running as well as in Pennsylvania, Georgia. And so they, are not bound by the rulings of the MDL court. And so not only might they, be speedier or less speedier on that track, but also they're applying different laws in state law. So without being able to speak to right now kind of the individual state laws, that's definitely something we'll see come to fruition about how those different state laws play out.
Hmm.
But yes, to your point would be an application of different laws. So we're definitely interested to see.
Hmm.
Because here at the federal level, we really get into the what's required to be on the label and, talking about the defendants and how they either, should have been warning against this or what testing they had done, either, testing their products or including on their warning that these weren't tested. So that consumers know when they're going to buy their products, what's it at risk of, because who's buying a chemical hair relaxer product to straighten their hair thinking, oh, this could cause cancer, if there's no warning on it, there's no way to know that.
So Lucy Banks, you've touched on at a couple of points, discovery and motion practice in the case so far. Any specific, what you would consider important motions that have already been argued and ruled upon that have affected the trajectory of this case, or anything coming up that is soon to be heard?
Yes, I think really this might be just also my personal involvement in the key discovery disputes. So a special master, Judge Jantz, is overseeing all of the ongoing discovery disputes. And so, we have these MDL hearings monthly to talk about, anything that's come up in discovery, which is always, a good number of things. And so, what might seem like a small ruling to some definitely plays a big part in the information that plaintiffs are able to obtain from defendants and use as we develop the case and answer a lot of the questions that, you've asked and pointed out as we prepare for Science Day, which you can see why Judge Rowland wanted to schedule that for after the close of discovery. So I think, every time we come out of those hearings in Chicago each month, those discovery rulings are really important and, move the ball forward in getting the information we need. I'm sure defendants would say the same.
So why don't we expand a little more on the bellwether process? As this has always been very interesting to me, how courts go about deciding how big the bellwether case pool needs to be, and how they go about stratifying and selecting cases that will be put up for those bellwether trials.
Yes, and this definitely has been a long process. Even when I was looking back, the different briefs that both parties submitted in trying to get a bellwether protocol in place, which is the case management order that the court published saying this is the process that will follow. So there was a lot of back and forth about what do defendants think is reasonably representative versus what do plaintiffs think, and of course we have different ideas of that. Not only in the number of cases, but then the types of cases that can, be a part of that pool. So, like I mentioned, one of the, just biggest things was that cutoff date. So, cases filed on or before February 1st were the potentially eligible cases. So, firms started by looking at those cases to see, okay, what is their number of eligible cases? And like I said, that meant there was about 6,500 that were presumptively eligible. And then this pool was limited down even further based on three main criteria, is kind of the way I see it, which is their designated injuries. So those three cancers that we talked about. And that means, having that medical information, the diagnosing records, looking at their different treatment records. And then second one is the execution of the participation agreement, which is that aspect that we talked about of, sharing resources, working together among the firms in the MDL, and the plaintiff being a part of that and sharing those resources.
So the bellwether pool has to be representative of the population as a whole, or should be. Are the number of cases in each injury category, is that being spread evenly across the population, or is it proportional to the cases, the disease incidence in the claimant pool?
Yes, that's a great question. And I can't give you a direct answer because I know the science committee is kind of taking on that prong, because the third prong is that those plaintiff fact sheets and how much discovery has been done on the plaintiff. So there's kind of those three pieces. And I know I know the order doesn't specify that those three
So,
types of cancers have to be spread evenly.
so that hasn't been decided yet.
Right, right, right. So we'll kind of see how that plays out. Because then that, the third element I mentioned of the discovery really goes to the plaintiff fact sheets. And I know that's what defendants and ourselves rely heavily on of, what additional information have we obtained from these clients as far as their personal information and background on how long they were using these products, when they were using them, being able to identify those products they used and when they used them. And then more medical information, which then defendants have the opportunity to drill down on even more in serving individual discovery requests. So those additional, more detailed interrogatories. And then, we get to do the affirmative defenses to those. So, figuring out that more individualized information. And then, of course, there's the element just, from the plaintiff side of figuring out, what clients are comfortable. They might have this case and are they comfortable going to trial and what that means. Because really we look at, the bellwether process as, like I said, being able to look at the strengths and weaknesses of the case and those that kind of set the stage for the rest of those hair relaxer cases that are out there. So, it's important to tell them up front, this is what trial might involve and this is what that process looks like. Because not everyone is familiar with that, especially if they're not involved in it.
Right. So while that's all going on, the bellwether process is unfolding in the MDL, and Science Day is fast approaching, or January is not that far over the horizon. You've got this state level litigation going on at the same time. Maybe in some regards on a parallel track, maybe there are dependencies where the state courts are waiting to see what happens at the MDL level. Can you just explain a little bit, are some of those state dockets? I know there are cases in Illinois, Pennsylvania, Georgia. I think there's also some proceeding in New York. Are those proceeding at their own pace on their own timeline, or are there certain critical hinges in the MDL that those cases are held up by.
Right. So since they're, on their own tracks, I think they definitely, I think even at different state levels are in different places. So they're kind of on their own timelines. Like I know Georgia, I want to say was one of the first states some cases were filed in, whereas I think Pennsylvania might be some more recent ones. So I think all of those are at different stages as far as how those cases are proceeding. I know the ones in Illinois in state court, they were looking at some motions to dismiss, whereas, the MDL, that was back in, was that the 2024, January 2024, when the court ruled on those. So the state court levels, proceeding in their own time. And a lot of that has to deal with, the laws and applying them, and then jurisdiction, can they be filed in a state court and figuring out those jurisdictional elements? Because that's the other big piece of the short form complaint and filing any case that, I didn't mention, but obviously goes without saying, having to, be able to have jurisdiction.
I know we want to leave a little bit of time for questions from the audience, and I've seen there's been a few dropped into the chat,
Yeah.
but there was one more, maybe a couple more topics we wanted to hit on regarding impacts beyond the MDL, specifically potential regulatory impacts and changes in behavior in the industry, et cetera. I don't know, we touch on these for a little bit. So any impacts at the industry level where there may be a push for more FDA oversight or broader discussions of gaps in regulation that are going on?
Yeah, I think this is a particularly interesting area and thing to think about with this litigation of, whether I'm talking about with friends or coworkers or someone that I'm traveling with to a hearing on the hair relaxer litigation. This kind of new area of what regulation is currently going on required of our personal care products, cosmetic products, like what is the law there? And then do we think there should be more? What should that look like? So that'll be something to very interesting to watch over time to see how that develops into other personal care products. Because I think it's something as consumers, we of course want to know that the products we're using are safe, and as we're choosing those products, choosing freely, which includes being warned about any risk that might be involved and having knowledge of those. Because it's scary to think, we could be at the store tonight picking out whether it's your deodorant, your shampoo, and not having any idea how it might affect your health later down the road. So I think that's definitely going to be an ongoing conversation that we only continue to see more, both at the legal level and among consumers.
So there was a question. I'm gonna actually pull a question that I didn't think of that's sitting here in the chat that somebody asked. And this is kind of related to this topic of industry impact and public health and advocacy and awareness in general of what is in consumer products. How was the sister study funded? And how are these any studies that have followed on this in the drafting behind the sister study? How are they funded? And generally, how are these studies initiated to begin with?
Yes, yeah. So that's a very good point. I believe the sister study was funded by the NIH, if I remember correctly. And I don't know, what other studies have been funded by them since then, off the top of my head. But that will definitely, be something that's touched on at Science Day of, educating on the science, but also I'm sure the judge, I could see that being a question of, who was funding the studies and then what additional studies have been funded around that. But yeah, that's what the NIH spurred that one on.
So that was public funding from the NIH, but probably not specifically focused on hair relaxers as a target, but studying ovarian, endometrial cancers, et cetera, and incidence rates in the population, right?
Right, because the study actually, that October 2022 one looked at other hair products, like personal hair products, that not just relaxers, but then the relaxers are the ones that showed that increased risk. So yeah, that's a very good point.
And there may also be other, and this will probably come out of Science Day, industry sponsored studies funded by private industry. Uh,
Right.
but to follow in the footsteps of the NIH study and get to the heart of what may be underlying these injuries.
Right. Because, like I said, that was really the first, epidemiological evidence that we had associating, um, the increased risk of those cancers related to the use of hair relaxers. So I think, yeah, that definitely only, provoked more studies to be conducted. So it'd be interesting to hear about those at Science Day for sure.
And on the general public awareness front, have you seen an increase in media coverage of these types of illnesses and the potential link to hair relaxers, and an increase in general public awareness?
Yes, I feel like yes. I don't know if that's of course since I'm more in tune to it, but I definitely have seen a lot of media coverage on this. I'm sure many of you might as well, as far as I've seen it on the news, and because I think to what I was talking about earlier, this is a conversation that affects everyone. We're all consumers in some way or another and purchasing personal care products, so it affects everybody. Even if you're not using chemical hair relaxer products specifically and it's thought provoking in that way. So I think that's for a lot of the news coverage, and then also just the serious nature of the injuries and the very compelling stories that we've seen through our clients and plaintiffs. I know those have been covered a lot in different news outlets with our clients alone and on social media. Um, and just speaking engagements, and I think also that is bringing awareness to that. I've found that's a lot of our clients, and that's how they figured out that they might have a potential case, is through a lot of times they say it's through something they saw on social media or heard about due to the recent science that came out around it.
I think anybody who has been through or has had a family member or a close friend with a cancer knows there are a lot of social media groups, health advocacy groups around these diseases where a lot of information gets shared. So,
Yes, yes.
um, anything else you want to say on the potential impact of this on other areas of litigation before we get into some of the other questions that are being dropped into the chat?
No, I think really just any last minute thoughts was just that this is definitely going to be a conversation I think we only continue to see more of. It'll be interesting to watch. So it's an exciting opportunity to be on the forefront of, like we're talking about, just, these very compelling stories and serious injuries, and hearing our client stories. And hopefully this will just broaden that landscape for you to do that for, more of these cosmetic products that people are buying just thinking, they're safe and that there's probably more regulation around them.
So this is a question that somebody raised in the chat. I touched on this, and I know you mentioned formaldehyde as one of the constituent chemicals, but have you learned anything, or the experts who are looking at these issues learned anything about the products made by these different companies? Are they all using the same chemical constituents in their products, or is there a great deal of variation?
Yeah, so I think that's going to be a big thing covered at Science Day. So I don't want anyone that's preparing for Science Day now to get mad at me for misspeaking. But from just a high level view, I think overall we're seeing a lot of similar makeups. Whether I mean, the getting into the detailed formulas, ingredients, all of that is definitely a much larger question.
Yeah, specific percentages and such.
Right,
Many
right,
of them
right.
do contain formaldehyde as one of the suspected carcinogens.
Hmm. Right. So I think overall we're seeing a lot of this similar, and then in the parallel to the marketing story, as far as at one point people were moving back more towards their natural hair, and then did those change over time? And same with, when they were marketing it to children and there was children's hair relaxers, things of that nature. So that'll be something, interesting to see if it's brought up at Science Day. And if not, definitely later on the litigation about how, if at all, those varied and what that means.
Right. And I know, Lucy Banks, you may not be able to answer this because it depends on what gets presented at Science Day, but I think it's a really interesting question that someone raised. Have any of the experts, if any of them, already addressed the role of potential hereditary genetic mutations that could be either a cause of these cancers, reproductive cancers, or a contributing cause?
Yeah, so I do know that definitely has been addressed as far as that was something considered in the bellwether, workup, that process. And that was part of the fact that it is included in that initial discovery is something, that is looked at just to, being able to suss that out. So that's definitely something being considered.
Oh, here's what may be a very simple question. Will Science Day be public or is this a closed hearing?
Oh, that is a great question. I Actually, let's see. I think I have the order up. I might have to follow up on that if there's a way to do that for the group because I'm not positive that it will be open to the public. But then again, if other judges are being invited, perhaps. So I'm
Yeah,
not
it'd be
sure.
very interesting to be a fly on the wall in that room.
Yes, yes. I'm
So,
sure if not parts of it will definitely be, the information that's learned and disseminated out of it will be
and
definitely.
you may have touched on this one, but it relates to the topic we kind of wrapped up with. Um, You mentioned the state stat or the federal statutes that are at issue here, but has the FDA actually regulated any of the chemicals used in these products?
So I know there was that, I think I spoke to this, the proposed ban on the formaldehyde that had come out. And then I know that deadline was missed about the actual banning. So it was not banned at that point. I don't think has been since,
Mhm.
which leads me to say no, unless there's something perhaps I'm missing there. But no, not as that I'm aware of.
So there's been an initiative, but that hasn't really resulted in a final regulation yet.
Right, right. Which could be for, yeah, a number of reasons, but definitely something, yeah, that's a conversation I know looked into and taken initiative on early on.
This is an interesting question. And do any of the plaintiffs who have these illnesses get any sort of assistance to deal with their disease, or any kind of support networks or assistance available to them while their cases proceed through the courts?
Yeah, so there can be various, that might look like various avenues just through hearing our various plaintiff stories. There's from not necessarily the litigation level, but seeing a lot of their community outreach. I know that's provoked a lot of interviews and clients telling their stories, but also know that there is, I'm not familiar with all the details of how it works with the certain companies, but do know that, um, clients have reached out about. I think clients are able to obtain through certain avenues, like, advancements on those, funding of litigation and what all that might require, especially as we talked about being selected as a bellwether and what that means as far as the deeper discovery of depositions and going to trial. So I think there's, definitely resources available out there.
Here's another question that was just dropped into the chat, and I'm gonna try to pronounce this, but I may stumble on it. Have any experts already addressed the role of endogenous formaldehyde in inducing cancers through induced haploinsufficiency?
Oh, wow.
What
Sounds
it
like they need to
means?
be at Science Day, whoever asked that. So that's like just with the expert reports in Science Day still being worked up and preparing for. I can't speak specifically to that. And of course, also there's an element of not only to blame of the future of Science Day, but also just the confidential nature of, what all is public versus not. So
So,
I can't speak specifically to that one for a number of reasons.
so,
But
so stay tuned. We may learn.
stay tuned. Stay tuned. Yes.
All right. Well, we're almost at the hour, and I want to take the opportunity here to thank Allison and the whole team at Perrin Conferences for all their great work in putting this webinar together. I hope you all of you listening in have learned a lot of very useful information here. I want to thank you, Lucy Banks, for taking part in this.
Yes, thank you for having me.
I've really enjoyed this. Allison, any final administrative work that you want to accomplish in the last few minutes here?
Yeah, I just again want to thank you to Verus for sponsoring the webinar and to Mark and Lucy Banks for leading such an engaging discussion. Everyone can look for an email later today with presentation materials and a link to apply for CLE. The three CLE code words were hair, status, and legal. I just see some other stuff coming into the chat. I see we have a couple more minutes. I don't know if there's anything else in here. Just a whole bunch of thank yous, it looks like. One question about, is there third-party litigation funding involved? Did we touch on that?
No, we didn't. I missed that one.
Yeah, which I don't know. I can't speak directly to that. If that might fall under one of those other resources that could potentially be available or that's out there, but I don't know specifically details surrounding that.
Perfect. Okay. Well, a lot of thank yous and great questions and very informatives and great presentations in the chat. So, again, thank you both for preparing this update for us. And everyone else, please look out for the email with the CLE link and the presentation materials from today. Have a great afternoon, all.
Thanks,
Bye.
everyone.
Thank you.